whether or not I had the authority as part of due process if there was a violation in regards to the Brown Act. I also consulted with the city attorney on that just to make certain I wasn't considered a legislative body. I am not a legislative body. I do things by ordinance and by charter, but at the same time, I am not having to comply with the Brown Act for this particular type of action. So the Brown Act does not apply here, and that part of the challenge, I think, as far as the appeal, really doesn't have standing. One of the other things that came through as part of the appeal was that their representative, the applicant, somehow was the one who initiated all of this, as well as claiming a hardship. From my perspective, and it's not to go out to defend the applicant in all of his different positions, and having not been a part of the history previously of this case, I'm not working in a vacuum, but I wasn't privy to all of the prior discussion or the hearings that transpired at that point in time, nor any of the negotiations that may have occurred with the constituents at that time and the immediate neighbors and adjoining property owners. But as far as this immediate process, the impetus behind this was not the applicant. The applicant didn't come in to claim a hardship and say, I can't do that. And the applicant has always been willing to meet their responsibilities on that, has been willing to negotiate as far as looking at different alternatives. And I would assume at this point in time, if there are new and different alternatives, would probably be equally open to doing so. And so I just think that at this point, to try and represent the applicant as coming in and claiming hardship, that never was presented to me in that manner. And one other point that they made as part of the appeal had to do with that all of this is dependent on vacation and Marywood, which I don't think, again, I think that's tail wagging dog. I think that this can be accomplished without the vacation of Marywood. If anything, that will enhance it and provide a wider corridor, and the applicant is willing to work with that. They have a relationship with the other property owner where they think that they can be successful in that. I can't make a guarantee as to what that would, the outcome of that vacation process would be. But at the same time, I would say that the Office of Zoning Administration would encourage that to happen, and I know that in talking with the council district, they're also on the same page. I think, I listened to Paul Koretz earlier make testimony. I think there's been some misunderstanding as to what the objective was here, and that the objective was never to try and undermine the need for that wildlife corridor there and the requirement for the applicant to provide that. I think that's always been our intent to fulfill that. It's just a matter of making certain that we did so within the correct legal confines. So with that, I'll stop.
Thank you very much, Ms. Wright. Mr. Bouchon, welcome. You have 10 minutes to make the presentation.
Thank you. For the record, Rob Bouchon, 15760 Ventura Boulevard, Encino, California. I think the one thing that I agree with Ms. Wyatt on, this is really a very unique case. I've been doing this for 30 years. I've sat on a board like yours, so I've heard a lot of these cases. I was a councilman's deputy, been involved in a lot of cases, and this is very, very unique. But where we disagree, and I know you've read all the material, I don't even have time to repeat everything that is in the written material, so I want to highlight what I think are the reasons why this appeal should be granted. Chief Zoning Administrator says that the letter of clarification is a proper exercise of her authority. It's not, and she makes the better case for it than I ever could. She has, on one hand, used the words correctly quoting from the code, the authority to clarify when a regulation is unclear. There is nothing unclear or ambiguous about Condition 19. The truth is, as she's acknowledged, that it's a legal condition in her opinion. She says on page 4 of her letter of clarification, a city agency cannot concede jurisdictional authority to an agency outside the city's jurisdiction. So there's nothing unclear about condition 19. You're just being told that it's a condition that is not legal. And it's interesting because if it's not legal, then why was it imposed not only by one zoning administrator, Sue Chang, in really one of the three cases that was heard on January of 2009, but also there was no hearing on the other two houses, even though it involved the same issues. So with my acquiescence, the chief zoning administrator, who is now our planning director, signed another decision letter October 13th, 2009 for the other two homes with condition 19, the illegal condition, signed off by Michael Legrand. So you have an illegal condition imposed by Ms. Chang and an illegal condition imposed by Mr. Legrand. It's not illegal. Here's why the zoning administrator, the chief zoning administrator, and why the city attorney's office, depends on who you talk to, happy to answer questions, because I had a conversation with the senior assistant city attorney yesterday who had a very different take on this. The reason they're uncomfortable with this, and it's the right reason, is that when you conduct a hearing, you should not concede authority to third parties. I agree. But that's not what happened here. What happened here is the zoning administrator conducted a hearing in January. It was a room full of people, more than you have here. The matter was taken under advisement. It was actually the former council office that, with my leadership, we got everybody together and did exactly what Councilman Koretz was telling you the way the system should work. We got an agreement, and that agreement is where the language came from on condition 19. And contrary to what the applicant will tell you, the applicant knew exactly where the Conservancy wanted the wildlife corridor and where they say it's critical to be there. If in your packet is the letter from the Conservancy with the map, November 2008. This is public record. It was in the city file at the time of the January 2009 hearing. So they knew where it was. They agreed to the language. They had an attorney. They had a civil engineer. And if they thought it was an illegal condition, forget about Ms. Chang and Mr. Legrand, they had two opportunities, not one. They had two opportunities to have appealed that condition. They didn't appeal it. And you folks hear cases, especially conditional use beverage cases, where the city has no authority to regulate the size of alcohol containers and all those items on that police list that they give prospective applicants. You don't have the authority, why do you impose it? I'll tell you why you impose it, because the applicant agrees to it. And that's what makes this case different, is you have an applicant agreeing to this condition, the language lifted from the agreement and put into the decision letters, both decision letters, and in the recorded covenant. The chief zoning administrator is also wrong that this is like CC&Rs. I deal with this every day. The city has a height limit of 26 feet. The CC&Rs, 20 feet. It'll get plan checked at 26 feet. So if someone wants to enforce the CC&Rs, they've got to go to court. Here, it's not that way. Here, the language in the private agreement is to the satisfaction of the Santa Monica Mountains Conservancy. It's the same language that's in both ZA decision letters. So it's not separate and apart like CC&Rs are. Probably the most important thing here is that you'll hear from the Conservancy verbally. I think you've already got some written letters from the Conservancy, that condition 19, the way it's rewritten, does not achieve the objective of the wildlife corridor. Now, there is an alternate plan that I just saw within the last 24 hours where the Conservancy said they would accept something different than what they said in 2008. And I've shown that to my clients, and they find that to be acceptable. And in fact, I would urge you to grant the appeal in part in order to put that specific corridor in the, or that defined corridor, that map, as an exhibit to the decision. Because if you roll back the clock, even I wouldn't be happy with that language. If you roll back the clock, what should have been done is the Conservancy's map showing the corridor should have been part of the decision. And if the applicant, even though he agreed to it, if the applicant thought it was illegal or didn't want to agree to it, then he could have appealed it. Of course, we would have been before you, and then you could have made that decision. But what good is a wildlife corridor if it doesn't accomplish the objective? I have the utmost respect for our chief zoning administrator, but there's absolutely no expertise that she has in wildlife corridors. Paul Edelman is considered among the best and brightest. And you're getting from him, and you're going to hear from, because he could not be here tonight, someone else speaking for him, talking about a missing gap here. It's not solved by city land that may or may not be vacated. So we do want to achieve the objective of the wildlife corridor. Finally, as a matter of law, this result does render the MND completely inadequate because the location of the wildlife corridor is now up for grabs. You've got the chief zoning administrator trying to accommodate the plans that were created by the applicant some 7 years ago. I understand why. You have the Conservancy, who are really the experts in this, telling you this will not accomplish the objective. So at worst, for me, there's a, or for you, you have a fair argument over whether you've got a workable, feasible corridor. This is not a taking. It's not a taking for two reasons. One, once again, this is not a condition that was pushed down the applicant's throat. He agreed to it in the hearing, he agreed to it in writing, and he further agreed to it in a recorded covenant and agreement. Secondly, all he has to do is revise his plans. I've talked to him. Yes, there might be some expense involved. Yes, it might affect location or square footage. But he can revise the plans, build his house, and still honor the condition that he said that he would agree to. I look forward to answering any of the questions that you may have. What we've tried to do, is, there's a lot of people that are here tonight, what we've tried to do is simplify it for you by having a certain order of speakers that we hopefully you'll call them in a certain order so that not everyone that filled out a speaker card is going to need to speak, and we'll probably just tell you they agree with what has been said. I look forward to the opportunity of addressing you again in any rebuttal, and again in answering any questions that you have. Thank you.
Commissioners, any questions?
Mr. Glushan, you mentioned that there was an alternative proposal that was reached about 24 hours ago from Conservancy.
I saw it about 24 hours ago, and I
Was
think
it-
you have it.
Was it circulated to all the parties, and has there been discussions with planning as well as the applicant in regards to that new proposal?
I got a quick look at something out in the hallway prior to the hearing, and whether or not that was an accurate depiction of Conservancy's representation, I don't know. It was provided to me by the council office, but I didn't actually get a copy.
Mr. Glushan, just a quick question to the applicant. Did the applicant receive a copy of the proposed amended Conservancy plan?
You're asking the applicant?
I'm asking the applicant. And if
We received a...
please come forward.
Good evening. Wayne Avershon, attorney for the applicant, 16133 Ventura Boulevard, Encino. We received a sketch of the attachment to the letter that you received. That's what we received. There was a letter sent by Mr. Edelman to the commission, I believe dated September 2nd, and there was an attachment to that. I received that via email from Mr. Edelman, I believe late last week.
Mr. Glushan, do you have extra copies of the...
I don't even have one. It was shown to me also in the hallway. But It's substantially the same thing as what they had proposed back in September or November of '08, except they've reduced the width as it goes down. But I don't have a copy of it.
If I may, Eric Graham, San Mike Mountain Conservative, you have it in exhibit number 9 in the packet that I gave you. It's the final page is our proposed compromise condition.
Is this it?
Yes.
Commissioners, I have a copy of it here. I have other orders that we can suggest that are staple to it. So if you want it all at once, we can do that, we can rip it out.
I apologize, President Ospina, for taking this out of order. What I was trying to do was, if there's some type of alternative that's on the table, I just want to make sure that all the parties had a chance to evaluate it and have some thoughts or comments in regards to that as a possible solution.
If I may to hopefully clarify this,
Mr. Glushon speaking.
Mr. Lucian speaking, thank you. Because this unique condition reads not to the satisfaction of the neighbors, but to the satisfaction of the Santa Monica Mountains Conservancy, I have advised all of my clients that if this is what the Conservancy has proposed, even though it is a reduced size corridor, if that's to their satisfaction, that we would, for the sake of clarity of condition 19, we'd be fine with that.
Thank you. Commissioner Camillo, please.
Is this the first time the plan has had an opportunity to?
This is the same exhibit that I was shown by the council district earlier this afternoon. I will say, I have no real objection to what they're doing as far as any of these negotiations here. I will say, in response to Mr. Glushon disqualifying me as an expert, I may not be Paula Edelman, but I have a degree in landscape architecture and I have an undergraduate degree in geography from UCLA with over 100 units in biology. So I know a little bit about this. But at the same time, I think to the extent that we can work again on negotiating and finding an appropriate alignment, I have no objections to doing that.
Thank you very much.
And if I can, I say 20 seconds left. This is Mr. Glushon again. My comment wasn't really meant to say that you're not qualified. I do think Paul Edelman is more qualified, but that's not the issue when it comes to an MND. The issue is if you have dueling experts, then the MND is inadequate. If there's a fair argument as to whether you're going to have a corridor that's going to work, then you need to have more environmental review, even if it's focused on the corridor.
Thank you, Mr. Rochelle.
Thank
Mr. Rochelle, you'll have 10 minutes, should you wish to use them.
Mr. Alvarez, before we get started, if I can ask Ms. Wyatt, I'm trying to get my bearings on this new proposal
Difficult.
compared to the map.
What you're looking at, this particular portion is essentially from there down. So the driveway where you see the portion, this essentially matches that. So coming down this way, this is the corner of the lot.
Sorry, Ms. White, can I ask you to take the microphone just?
So if you look at the alignment now, this is part of parcel number 3 on the exhibits the applicant provided. And it essentially runs from the far edge of Marywood and that corner of the property along the Marywood frontage all the way down to Stanley Hills, with the driveway access, the proposed driveway access to parcel number 3 would be done on the applicant's exhibit. So that the Conservancy is not concerned about the alignment that runs across the back of the property. They were perfectly willing to accept that from the applicant, thought fine if they'd like to volunteer that. That wasn't critical, but at the same time, they were more than willing to accept it. But at the same time, what was critical to them was this portion here along Marywood. If you look at the, I think at one of the, they may have actually a better depiction within their packet here. connection, what the objective is with the connections, and going from one side and crossing over Stanley Hills and connecting with a very large open space on the other side. I think that's a good drawing there, so that picture here in particular shows what the intent is. That's page 2 of, I think, the Conservancy's document. And you can see the two large, if you follow the green pathway, you can see what the intent of the connection is.
What is the current condition of Marywood Drive?
It is it's partially improved, but it's sort of a dirt roadway at this point. There's portions of it that are improved, but along that particular section, I think the applicant give you a really, I haven't been out there in quite some time, so I can't tell you exactly what that portion looks like.
So
It's not an improved street, paper street essentially at this point in time, but not fully improved.
the reason why I was asking is based upon the package that was submitted by the appellant.
I think it's- Maybe the appellant probably in a better position to explain some of that, only because it's the first time I've seen it is this evening.
I was looking at pages 6 and 7.
Yeah.
On page 6, it makes reference to Marywood Drive, and it looks like,
I would have to refer to the appellant on that to explain how they've taken the picture.
thank you very much. And you are always an expert.
Mr. Evershed.
Yes, sir. Thank you, Commissioners. As a point of just background, I too, as Mr. Glushon, was the deputy of 2 Los Angeles City Council members, including a long time ago, Council District 5. So I think I understand this. I sit as a county-appointed commissioner in a joint powers commission presently. I understand Councilman's position in terms of the political aspects of it, but I urge you to look past the political aspects of it. There are legal precedents here, there's authority here, and there's a delegation by the city, an original delegation, to approve a condition to a third party. And Ms. Wyatt has been with the city many years. As Chief Zoning Administrator, I think she understands it very well. The city cannot delegate that authority to clear a condition to an unrelated third-party entity. Can't do it to the Conservancy, can't do it to the Chamber of Commerce, can't do it to a neighborhood council. So it was an inappropriate, but it was more than inappropriate, it was confusing. The appellants talk about condition 19 being crystal clear. If you read condition 19 and read it carefully, it has 2 paragraphs. One paragraph concludes to the satisfaction of the zoning, to the Conservancy. The second paragraph concludes to the satisfaction of the zoning administrator. It is not a crystal clear paragraph. The code, it gives the zoning administrator the authority, and in this case, the necessity to clarify ambiguities, and in this case, clarify what you can call it. I don't want to get hung up on semantics, mistakes, an improper delegation. The zoning administrator has a right and a duty to do so, and she did it. We should all be proud of her efforts and support her efforts. Very, very critically, my client did not volunteer this condition. My client did not, and frankly, no client I know in the real estate development business would say, okay, I'm going to have the corridor decided by the Santa Monica Mountains Conservancy. Because what could happen, and I don't want to blind anybody with a laser, but what could happen happens somewhat here. Maybe it's too far. But if you leave it to the satisfaction of the Conservancy, what if the Conservancy ran the 20 feet through all 3 lots? Importantly, the Conservancy, Mr. Glushon talks about a letter by the Conservancy. I've distributed that letter. I'm proud of that letter. It was November 2008. It was a letter, if you look at what it's regarding, it's not regarding a ZA case number, it's regarding the environmental impact report. As we all know, when the EIR is circulated, the city can get 2 letters, they can get 100 letters. Those letters have no legal authority. Those letters are comments. Mr. Edelman did comment where he would like it to go. We were aware of that, but then that was November 2008. January 2009, the city acted in approving the variance and approving 3 lots in the houses in designated locations. The site plan was part of that approval. The city did not incorporate Mr. Edelman's suggestions. We did not agree with it. The city did not agree with it. And if you look at Mr. Edelman's letter carefully, and I highlighted it, because this is a unique matter, and it's a matter that requires a detailed analysis. In the 3rd paragraph, Mr. Edelman writes the Conservancy request. In the last paragraph, we appreciate the city's consideration of these recommendations. Mr. Edelman knew, everyone knew, the Conservancy can recommend, but the city is the deciding body. And then in November of 2009, at a Hall Route hearing, the appellants and Mr. Edelman showed my client at that Hall Route hearing, here's where we want the corridor. The corridor went through the house in lot 3. Mr. Edelman wants a corridor through a living room. Now, I consider that after the city approved 3 houses in that site plan, not in the abstract, those 3 houses, if you run the corridor through 3 houses, it's a taking. You run it through 2 houses, it's a taking. You run it through 1 house, it's a taking. What the city did, what the planning department did, judiciously attached 20 conditions, every other one to the satisfaction of the city department. The city granted 3 lots. Now, the Conservancy wants, and they put in a letter to you, they're very upfront, they put in a letter to you very recently, last week, if the applicant cannot do that, then he urges the commission to revoke the grant. Well, with all due respect, the Conservancy does not have that authority. But this is a backdoor taking, because the current corridor that Mr. Edelman has now reduced down to 15, and it's a step in the right direction, again, it runs through the living room. So it's nonsensical. It's nonsensical. I've been to the property. It's 1 block from Laurel Canyon. It's a lovely area. The corridor will go to Stanley Hills Drive. I'm not a biologist. I'm an attorney, former council deputy, former real estate guy, developer guy. It doesn't appear to me to be the wisest course Mr. Edelman wants, because his deputy, his assistant, will tell you this evening that the animal goes down the hill and crosses Stanley Hills, and it dodges a car or 2, it goes across the street, and yes, there's a lot of houses there, but there's a fence there, but we're gonna carve out 10 feet. So if the raccoon or deer makes it through, goes on Stanley Hills, it may or may not get through. We wish it well, but it's a tough assignment. But we want to work this out. We did not volunteer the condition. We believe the ZA had a duty to clarify, and they did clarify. The code tells us they clarified, and the process is important. The details are important. We have also given you different alternatives. We met with Mr. Edelman last week in my office. I've known him some time. We tried to kick around different ideas. We tried to work it out. We said we'll give you more footage. So if you look through this quickly, we have under 4 minutes, and I'll just take you through it quickly. You can look at it. First page is the Paul Edelman proposed corridor back via the EIR comment letter. We never agreed to it, and the city did not agree to it. The second page we call the Lynn Wyatt plan. Maybe it should have been the Chief ZA plan, but what have you, it's got a photograph. It has about 7,500 square feet. That's Ms. Wyatt's plan.